I do not.
Thank you. My name is, thank you for this opportunity to speak, and thank you for the extension of the comment period to 90 days. My name is Jim Knowles, and I'm an attorney with the law firm of Balchin Bingham, where I practice environmental law. I represent a number of private property owners in Bibb and Perry County, and they have land within or adjacent to the proposed expansion. And I'd ask y'all to stand up if you don't mind. Ms. Davis, Ms. Belcher, can we see who's out there with me? Rosalind? If any of y'all got any of these kind of questions been raising, you might want to talk with them as well. They've retained my services because they are concerned about this expansion and this federal action at hand. And our position is that an acquisition of this magnitude of over 100,000 acres requires, at the very least, an environmental impact statement as required by the National Environmental Policy. And it's sort of ironic because I think a lot of the root of the problems that we have here, and in fact, the reason we're here right now is because such an environmental impact statement was not initiated from the beginning, and that's why you have so many questions. If it had been initiated, I think we would have had the public input process, the public notice process, a public scoping process that could cause a lot of these questions to be answered on the front end. So that is something that we certainly are going to insist occurs. I'll tell you, I appreciate what you're saying, ma'am, but the public notice was just absolutely inadequate on this. And to hear that we can't, I mean, someone hit the nail on the head out there in the audience. If you can't manage a public notice mail out, how do you anticipate managing 100,000 acres? I've also got to say that with respect to the eminent domain issue, we're just receiving very mixed signals. I mean, they're mixed signals within the four corners of the environmental assessment. They talk about only purchasing it from willing sellers, but at the same time, they talk about their right to eminent domain. And I've seen the references to policy up here, but policy is policy. I didn't even see a citation to a particular policy statement. We really, really need, I think, some kind of formal clarification, some kind of formal assurance, again, at the very least, about whether or not eminent domain will ever be used. Because I've got to tell you, folks, just as I was scrambling to get ready for this, I was able to find two cases. One was from 1967 involving the Yazoo River National Wildlife Refuge, where the Fish and Wildlife Service used eminent domain to extinguish a hunting club's lease over a property that had been taken over for the refuge. Another one occurred in 1987 in Washington with Protection Island National Wildlife Refuge. Thanks. And in that situation, a couple's coastal property was taken from them. So I don't think assurances of, oh, we never do this or it's against our current policy is going to work. Look, we're talking, by the way, this acreage, $290 million. If you use their figures, it's going to cost the figures within the environmental assessment, $290 million. Where is that money coming from right now? That just baffles us at that point. You know, actually, I can tell you, folks, I'm out of my time. I want to respect this unless any of my clients are willing to cede their time to me at this point. Okay, I'll just continue here, and I will be brief. You know, at the present time, we're seeing reports of a $9 billion backlog in the budget in the Department of the Interior for necessary repairs, maintenance, and improvements to Department of Interior property. Again, if you've got a $9 billion backlog, why are we taking on another 100,000 acres here? Fourth point would be, is this proposed expansion necessary or even desirable? I think those points have already been made, but when you look at the main point I want to make is when you look at the environmental assessment and the alternatives, they only offer three alternatives. No action, what we want to do, and what we want to do taking out the conservation easements. There are lots of other alternatives than that, and that's the kind of thing that would come out in an environmental impact statement. With respect to the conservation easements, I do think we need to see a precise language on just what they are expecting, because that will affect your land. It'll be a negotiation but it's going to be something you'll want to consider. Related to property rights, this is very important. We're not just talking about surface rights. Here in Bibb County, in Perry County, up in Jefferson County, you've got surface right owners, you've got timber right owners, you've got mineral right owners, you've got utilities that have easements that go across. And I mean, it's just a mess. And again, that's got to be assessed fully. You just don't see that in here. On a similar note, I'm going to point out that at the back of that document, the interim compatibility determination does not list those uses as being compatible with a refuge. So I'd like to see how that's going to play out. Finally, one more point. Admittedly, the Federal Refuge Revenue Sharing Act is intended to provide those tax dollars as compensation for what's being lost. But that act only provides the money as it is funded annually by Congress. And as Steve mentioned, we've already gone from 4 times what we're receiving in taxes to 2 times what we're receiving in taxes. Where is it going to go next at this point? And again, we're depending upon a Congress that's already running a $13 trillion deficit at that point to fund that. And that really just brings me back to my final point. Thank you, Sherry, for for going over here. An environmental impact statement, absolutely necessary. I think you'll find it very reassuring if we even go to that point. Thank you.